Welcome to An Ounce of Prevention, the podcast. At our recent associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, the podcast, where we believe an ounce of prevention is worth a pound of cure. I'm your host, Rachel Reese. Today on the podcast, we're going to be talking all things force majeure, and this is the last episode of our commercial contract series. With all the uncertainty in the market lately, we're getting a lot of calls on this, so I thought it would be a good idea to take some time and explain force majeure. After, be sure to stick around to hear our much-loved Caselaw update, where I'll be unpacking how Texas courts strictly interpret force majeure clauses in energy contracts.
Attention, all you Dealmakers in the Houston area. Get ready for the inaugural Dealmakers Haunted Hall Gala on October 23rd at Meow Wolf Radio Tav. It's going to be a night of networking, giving back, and some spooky thrills. The Dealmakers Haunted Hall Gala is your chance to meet with industry leaders while making a real impact on the communities we serve. This event isn't just about fun, it's about giving back to those in need. We're looking for sponsors to help make this event a success. With sponsorship levels ranging from $2,000 to $5,000, every contribution goes towards supporting local communities and making a difference where it matters most. The more sponsors, the greater the impact. We need your help to make this unforgettable. Visit www.rreeselaw.com for information about events, tickets, and sponsorships. Email rlampier@rreeselaw.com to sponsor and be a part of something bigger than just an event. Let's make Halloween one to remember. Dealmakers Haunted Hall Gala, where the networking meets charity in the spookiest way possible.
Okay, so people will call and ask, can I use force majeure in this certain situation? And our response is always the same. Well, what does your contract say? Contrary to popular belief, force majeure is not a thing under common law. Some states have a defense of impossibility, but force majeure itself is a creation of contract. So if it's not in your contract, it's not something you can use. But what is force majeure? Well, generally speaking, it's a provision that you put in your contract that says that a party can be excused from performance under certain circumstances. Examples of these circumstances are floods, hurricanes, tornadoes, your typical acts of God stuff. But also things like regulatory issues or the inability to obtain materials. During COVID, we saw some folks invoking force majeure because the municipalities that they were working in had a quarantine or a stay-at-home order. Does that qualify? Well, it depends on what your contract says. Because once again, we're talking about a creation of contract. The provision can be as broad or as narrow as you want it to be. So you may be thinking, great, I'll just make it as broad as it can be. But it's going to apply to both parties. So depending on the type of contract you're talking about, that may or may not be the best option. So I'm going to end with some best practices here. 1, read your contract. 2, if you still aren't sure, call a lawyer for advice. 3, send whatever notice is required by the provision. And last, keep good records of what prevented you from performing, what actions you took and when the force majeure event ended. Okay, that's all for today. I hope you learned something. If you have any questions about the force majeure provisions in your contracts, give us a call. And now it's time for another case law update. Today, we're diving into a topic that has received renewed attention lately: the concept of force majeure and how it applies in Texas energy contracts. While not all of these cases are hot off the press, each one offers essential lessons that are particularly relevant in the current climate of commodity price swings and operational uncertainty. The first 2 cases illustrate how Texas courts handle force majeure claims tied to economic downturns, while the third case deals with force majeure claims and internal error. In Valero Transmission Company versus Mitchell Energy Corp., before the First Circuit Court of Appeals in Houston, Valero sought to avoid its obligations under a gas purchase agreement by invoking a force majeure clause after market conditions shifted and made the contract financially unfavorable. But the court was clear. Just because a contract becomes more expensive to perform doesn't mean performance is excused. The force majeure clause in question did not specifically enumerate economic conditions or market fluctuations, and the court emphasized that market downturns are foreseeable as a matter of law. In the court's own words, an economic downturn in the market for a product is not such an unforeseeable occurrence that would justify application of the force majeure provision, and a contractual obligation cannot be avoided simply because performance has become more economically burdensome than a party anticipated. The court went on to say that the uncertainty of future market prices is often, in fact, the reason for entering into a long-term contract. So now we fast forward to 2018, when that same Texas appellate court echoed similar themes. In TEC Almos LLC versus ConocoPhillips Company, TEC Almos failed to perform under a drilling contract and tried to invoke the force majeure clause due to a drop in oil prices. But the clause didn't mention price declines or market conditions. Instead, TEC Almos relied on a catch-all provision and argued that the market drop was unforeseeable. The district court disagreed and held that catch-all language still requires the event to be unforeseeable, and the driller did not and could not show this because market fluctuations are foreseeable as a matter of law. Moreover, in applying Texas common law, the court found that economic hardship, even severe economic hardship, is not a basis for excusing performance unless the contract says so. So again, the lesson here is straightforward. If you want price drops or market events to trigger a force majeure clause, say it explicitly in your contract. Otherwise, the courts will not do you any favors. Finally, let's look at a more recent decision from the Texas Supreme Court that tackles a different angle. Whether the event being used to invoke force majeure has to actually cause the delay or inability to perform. In Point Energy Partners Permian LLC versus MRC Permian Company, MRC Permian had a lease that required continuous drilling to maintain the acreage. After completing one well in November 2016, the company had until May 21, 2017 to spud the next well. But they didn't start drilling until June 2nd, 12 days too late, because of an internal scheduling error. Upon realizing its mistake, MRC attempted to invoke the lease's force majeure clause, pointing to a 30-hour delay caused by operational issues on an unrelated well in April of 2017. MRC claimed that this delay extended the drilling deadline by 90 days, but the court rejected that argument, holding that force majeure clauses must be strictly construed based on their language, and that the event cited by MRC did not cause the missed deadline. Instead, the delay was the result of MRC's own internal scheduling error. The court emphasized the core principle of force majeure here, that force majeure can only be invoked when the event directly causes the failure to perform. Here, the clause covered delays caused by a force majeure event, but the actual delay in spudding the new well was due to MRC's scheduling error, not the unrelated operational issue. Because the force majeure clause did not apply, the lease terminated as to all non-producing acreage. To recap, Texas courts interpret force majeure clauses narrowly, and each case turns on the specific language used. Market changes and internal errors are foreseeable and not enough to excuse performance unless expressly stated in the contract. If you want out of a contract due to market volatility or operational issues, you better have planned for that when drafting your contract. If you need help drafting or interpreting force majeure clauses or enforcing the terms of your contracts, let RRNA know. We are happy to help.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RRNA or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese & Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RRNA's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. Follow us on LinkedIn or call 832-831-2289.